Hello and welcome to the first of a series of 3 seminars. There's the second 2 are dates TBD and content TBD, to be quite honest. But it'll be 2022, so something to look forward to in the new year. But there'll be issues affecting corporate trustees in the same way as this one. Our purpose for doing this is really twofold. First of all, we hope that the content that we're providing you'll find informative and engaging. And secondly, also we wanted to kind of provide a bit of social interaction. We've sort of all missed over the last 2 years, so hopefully you'll be able to stay around afterwards for a drink. Ironically, given the subject matter, we haven't actually provided for any kind of virtual attendance, but it will be on YouTube. Genuinely will be on YouTube after the event, so it's likely to go viral like PewDiePie. My son told me to mention him. I don't even know what that means, but maybe you do. I've been asked to keep the introduction quite light, so mentions of sort of supply chain issues, Brexit, IBOR discontinuation, and global pandemic are trying to downplay those a little bit, but they will crop up at various points during the seminar, I'm afraid to say, inevitably. So today we've kind of split it into 2. Ben and I are going to be covering virtual meetings and issues which have kind of arisen as a result of that development. And Jayesh and Charlotte will be covering the new restructuring plan under SIGA. So I think without any further ado, I will just dive straight in to virtual net holder meetings. Okay. To start with, just a bit of context for what we're talking about. In our kind of analysis, the ability to seek instructions at a physical meeting of note holders is a cornerstone of the trustee function. And whilst the trustee will always have the ability to actually agree certain changes and certain waivers without note holder consent, in practice the trustee is going to be quite disinclined to do that, other than in very limited circumstances. So a trustee will typically provide for that to be an option where you have a modification or waiver which is not materially prejudicial to holders, or where there's a manifest error or a proven error, or where there's a subject matter which is formal, typographical, administrative. But even in those circumstances, a trustee will, if properly advised anyway, be disinclined to act in the absence of note holder instructions, other than in a very, very clear-cut situation and probably with the benefit of legal and or financial advice to actually underpin the decision-making. So that's kind of the backdrop. And then in practice, there are 2 principal ways in which the trustee can actually derive its instructions. One is a physical meeting of note holders, and then second is the written resolution procedure. So just a word on that really at the outset. I mean, there is a superficial appeal with a written resolution procedure, which is less cumbersome from an admin perspective and certainly less expensive than a physical meeting, and also can be kind of put in place relatively quickly without the kind of the minimum notice requirements that are attached to a physical meeting. However, against that, obviously the written resolution procedure has certain pitfalls in that typically the required voting threshold is 100% or a similarly high number, so the proportion of holders to vote in favour, which can be quite challenging. And whilst we've seen recent issues, and particularly on restructured deals, where the kind of requirement is set at a much lower level, say sort of 51%, in our experience, unless the subject matter of the proposed resolution is so compelling as to guarantee participation from a big number of holders, that it doesn't really get off the ground. And so in practice, the physical meeting tends to be any way of actually kind of proceeding. And in addition, finally, as a sort of more intangible benefit for a physical meeting, there is the appeal of actually bringing the trustee into direct contact with the beneficiaries so that there can be discussion of issues of kind of common interest and common concern. So there's that kind of perspective as well to consider. Okay, sorry about the next slide. So yeah, keeping it light. It's unfortunate that at a time of uncertainty and upheaval caused by certain known factors, so Brexit, IBOR discontinuation, and then certain unknown factors, the global pandemic. So at a point in time when you really needed the ability to kind of have these meetings to actually kind of make decisions happen, it's been severely compromised by the kind of the lack of ability to actually have physical meetings. As a result of obvious kind of geopolitical and kind of macro health issues and restrictions on movement and travel. And so, whilst the varying degrees of restriction that have characterised the last 2 years have had a critical impact on the ability to hold physical meetings, we're going to spend the next sort of 10 to 15 minutes or so just trying to basically summarise kind of where we've got to, what lessons can be learned by the market's attempt really to muddle through and find a solution, and also consider what note-holder meetings might look like in the sort of post-pandemic world. So let's get rid of that slide. Okay, so back to basics in terms of virtual meetings. I think the way we analyse it, the fundamental challenge for physical meetings can be summarised thus. So, in a world where at one point physical interaction outside the immediate family unit was prohibited, how could you possibly canvass a broad constituency of holders or their proxies to provide instructions to the trustee? Short answer, you couldn't. So we've kind of talked about written resolutions already and kind of the unachievable voting threshold sometimes, and the kind of the prospect of note holder apathy, which might rule that out as an alternative. So what you were left with was the concept of virtual note holder meeting. So a virtual note holder meeting in this context would just mean really that a meeting where the participants aren't physically in the same location, and they're typically conducted through some sort of teleconferencing facility or another digital platform. So scenario where participants can hear each other, see each other, but can feasibly participate from anywhere in the world. And a further distinction to draw as well is fully virtual meetings and hybrid meetings. So the fully virtual meeting is a meeting where the participants are conducting the proceedings purely by electronic means, so all parties participating remotely. And by hybrid, funnily enough, a combination of that, so where there'll be some limited physical attendance, so typically the chairperson or tabulation agency or representative of the tabulation agent, with other participants, so typically the note holders or their proxies, attending by electronic means. So that's a kind of quick canter through kind of key terminology. And then just a pause as well, just in terms of what the general law says about meetings and virtual note holder meetings. And long before the global pandemic, English courts have accepted that meetings, specifically for the purpose of the Companies Act, can be held without the meeting being face-to-face. And that's a commonly accepted principle that has been affirmed by recent court decisions. And then Charlotte and Jayesh will come on to this, but in addition, the various kind of provisions that have been brought about as a result of SIGA are also supportive of measures being taken by issuers to hold meetings virtually. So that's all good stuff. And whilst note holder meetings are different from meetings for the purpose of the Companies Act, in that they're not governed by statute, they're governed by the provisions of the trust deed, the court's interpretation of what a meeting is for the purpose of the Companies Act is helpful in determining what is a meeting for the purpose of a note holder business. So that's all good stuff. And what we've kind of experienced as well is that the standard meetings provisions of the trust deed don't prohibit virtual note holder meetings, but similarly they don't expressly provide for them either. So that's kind of where we are. So where we come down to, and where we'll kind of spend the focus of this part of the session, is that English law trust deeds will typically confer a power on the trustee without note holder consent to prescribe regulations for the holding of a note holder meeting, and the drafting on the slide there is the kind of typical wording that you'd expect to see in the context of an English law trust deed. And then similarly, in addition to the power to confer regulations, there's also the discretion to waive breaches of the trust deed, again without note holder consent. And a trustee would only do that if the trustee considered that as a result of that waiver that there wasn't any material prejudice attaching to the note holders. So I think in our experience, that any decision by a trustee to agree to the use of virtual meetings involves probably both the power to prescribe regulations and also the discretion to waive breaches. But in our view, it's not necessary for most of the times to actually have a formal modification of the trustee provisions. So then the key question becomes, is a virtual note holder meeting an appropriate use of the trustee's discretion? And at that point, at the difficult question point, I'll hand over to them.
Seamless. First technological error. So with apologies for sitting on the fence immediately, the answer is that it will very much depend upon the exigencies of any given set of circumstances. Certainly, in our experience, meetings that facilitate the virtual participation of note holders are becoming more and more commonplace to smooth the efficient execution of time-critical transactions. The key, as John said, is that note holders must not be materially prejudiced by the manner in which the meeting is being held. So for example, and we'll come on to look at this in more detail, any regulations that are prescribed under the provision contained on the slide should be agreed between the key stakeholders in advance and clearly explained to all participants. A note of caution though, the developments around virtual note holder meetings have taken place in the context of a global pandemic, as we all unfortunately know. And it's difficult to think of a set of circumstances that are more well suited to the deployment of commercial and creative solutions than COVID-19. So you do have to wonder whether these mindsets will change as we start to go back to normal and the world opens up. For example, you can see a set of circumstances where a note holder comes along and challenges the outcome of a resolution part of the virtual meeting on the basis that they were potentially unable to participate because of a technological deficiency. In our view, this is a particular risk in a distressed situation, such as in connection with the compromise of claims. So the particular procedures to be followed in terms of how a meeting is convened and conducted are key to ensuring that the interests of note holders are not materially prejudiced. Now, a virtual note holder meeting, as John said, is a significant departure from the traditional meeting mechanism envisaged by your standard trustees. The challenge for a trustee or an issuer is to balance pragmatism in introducing appropriate and adaptable modern procedures with prudence to ensure that secure and robust methods are employed to safeguard holders from material prejudice. And we will briefly consider 3 potential obstacles to the successful use of virtual meetings, together with a corresponding practical solution. So first of all, typically, notices of meetings will give, amongst other things, 21 days notice of the date, time and place that the meeting is going to be held, and will generally state the nature of the business to be conducted. However, they will not specifically contemplate the possibility of holding a virtual meeting. So if it's apparent or anticipated that a physical note holder meeting will not be feasible or desirable, the notice of meeting should explain that a virtual note holder meeting will be held as opposed to a physical meeting, and it will also explain exactly how the virtual note holder meeting will be conducted in practice. In particular, the notice should specify in detail how note holders will be able to participate and in the virtual meeting by reference to the relevant digital platform that is being deployed. Just by way of example of the level of granularity which may be required, you'd want to consider statements to the effect that note holders wishing to attend will need to ensure that they have a stable internet or telephone connection. It should explain that details of that digital platform will only be provided on the morning of the meeting to, so far as possible, prevent unintended distribution. It should also explain that alternative telephone dial-in details will be provided in case, for whatever reason, a note holder drops off from their internet connection, which I'm sure we've all experienced in the course of the last however many months. And that crucially, neither the issuer or the note trustee will be liable if any note holder is unable to participate because of a technological problem. The second issue is determining who is in attendance for the purpose of satisfying any necessary quorum requirements. Now, as we all know, note holders will usually not, even in connection with physical meetings, attend in person, but will instead appoint a proxy to attend and vote on their behalf. But that's not an easy fix, because any proxy will have to go through the same identity verification process as a note holder who wishes to obtain a voting certificate and attend the meeting, usually to interrogate the transaction parties on the nature of the business that's being conducted. So how then can a chairperson verify the identity of a note holder in attendance? Well, the relevant clearing systems will provide the paying agent beforehand with the name, email address and passport number of those note holders who wish to attend. Prior to the meeting, the note holders provide a scanned copy of their passport, and those details will need to match in order for the note holder to obtain their voting certificate. When that note holder then joins the virtual meeting, they will circulate their executed voting certificates or forms of proxy on a designated email chain, and the chairperson will then be able to conduct a roll call before announcing whether or not the meeting is quorate. So it's a little bit of faff, but it can be done, and it's not a sticking point when it comes to implementing a virtual meeting. The third question that we wanted to have a quick look at is how those attending can vote. And the notice should warn attendees that they may need to print, sign and return scans of certain documents during the virtual meeting in order for votes to be cast on a poll basis, which is how obviously the majority of votes are measured. If an attendee can't physically get pen to paper or doesn't have a scanner readily available, then in our view an e-signature platform can be used for that purpose. And at a physical meeting, voting cards are circulated and submitted to the teller, who will complete the voting record. In our view, this same process can take place electronically, with executed voting cards circulated in real time on the same designated email chain or via an electronic document exchange platform. Now this obviously is not a complete and exhaustive summary of the obstacles that a trustee may face in connection with the virtual meeting, but hopefully it gives you a flavour. What is regarded as best practice will continue to evolve and is necessarily dictated by the context of the transaction in question and the preferences of all the stakeholders involved. So, I guess the key question. 2022 is likely to usher in a glut of liability management and restructuring opportunities as struggling issuers seek to manage their outstanding debt. Throw LIBOR discontinuation, post-Brexit fallout and any legacy COVID-19 repercussions into the mix, and you have the perfect storm. In a febrile and dynamic environment, one can easily see how timely noteholder instructions will become more and more critical, but less and less easy and straightforward to obtain by traditional means. But will virtual noteholder meetings be commonplace as the world opens up? Well, the International Capital Market Services Association are supportive of virtual noteholder meetings, but as you can see from the slide, they have ostensibly limited their support to while COVID-19 lockdown restrictions remain in place. That said, even post-lockdown restrictions, they recognise that we're likely to see an increase in virtual noteholder meetings, and that this may be a pragmatic solution as virtual meetings can be efficient in terms of time and cost as remote working becomes more and more commonplace. From a trustee perspective, the key consideration, as we've said, is that the use of a virtual noteholder meeting must not, in any given set of circumstances, materially prejudice noteholders. And this involves careful consideration of how the practical steps which are being taken to ensure that holders will not be disenfranchised by the fact that the meeting is being conducted virtually. It also involves consideration of the wider context in which the virtual noteholder meeting is being held. For example, a trustee should be more wary of virtual meetings in a distress scenario, where the overall risk profile and the likelihood of challenge may be materially greater. Ultimately, the transaction party should think carefully before going down the virtual route, where a physical meeting could be held instead. And having said that, whilst no form modification of existing trustees is required, we do understand that trustees at the moment for new money issues and restructurings are beginning to expressly provide for virtual noteholder meetings in certain circumstances. We would suggest that such provisions remain flexible as market standards and noteholder expectations develop. But we're confident that demand for this will only continue to increase. So even in the absence of unique and, sorry to say, unprecedented events like COVID-19, it's likely that virtual noteholder meetings will become a legitimate and pragmatic option for issuers and trustees going forwards. And that is all that John and I had to say. Does anyone have any questions or observations of things that are seeing in the market at this stage before I hand it over to Charlotte? Perfect. I'll do just that.
Not to trip over that wire. Take my glasses over this laptop. Right. So first of all, lovely to see you all. So nice to have you all in the building. Okay, so today I'm going to talk to you about the new restructuring plan. But before I actually dive into the detail about that, I thought it probably made a bit of sense to take a step back and actually think about what we actually mean by restructuring and what devices are currently available to help us with that. Okay, so a restructuring, sometimes also referred to as a workout or a turnaround, effectively means a process where a company and its creditors are agreed to reorganise, if you like, the liabilities of the company. And there are various ways that that can be achieved, because the term restructuring is a very broad church and covers a lot of different things that can be done. So at one end of the spectrum, it can encompass really relatively simple amendments to debt documents, and I'm sure that we've all seen quite a few of those taking place during the pandemic. So, for example, extending maturities, changing margins, perhaps taking new and additional security to shore up a creditor position, for example. And at the other end of the spectrum, we might be looking at a drains-up, full-blown restructuring of all the financial and non-financial liabilities of a large corporate group which is in distress. And that can involve looking at debt at lots of different levels in a corporate group. It can involve implementing cost-cutting measures, such as closing unprofitable businesses, and it will often involve some kind of compromise by creditors. But ultimately, the purpose behind it is to try and avoid the loss of value that you were going to get if that company goes into an insolvency process, such as administration or liquidation. Now, by definition, a corporate debt restructuring is implemented on a consensual basis by way of contract between the companies and its creditors. But the restructuring process might also involve a statutory procedure, such as a CVA, a company voluntary arrangement, or a scheme of arrangement, or one of the new restructuring plans, which I'll come on to talk about in a little bit. CVA schemes and plans effectively consist of a negotiated contract between a company and its creditors or members that it's enforceable under statute, subject to challenges in court. And ultimately, the extent to which that consent to a restructuring is obtained from the company's stakeholders, voluntarily or with the support of a court-imposed sanction, and indeed what kind of court-imposed sanction might be the appropriate one, is going to depend on a few variables. So, for example, what's the nature of the liabilities that need to be restructured? And what authorisations would be needed from the relevant class of creditors? So are there majorities required to support the restructuring, and are those going to be achieved? And these are often going to be things that are influenced by the creditor's view on the value of the business that's being restructured in the first place. Now, the approvals that actually are required to restructure a business are going to depend on the company's debt and debtor profile. But they could, for example, include majority or all lender consents for syndicated loan debt, for example. There could need to be extraordinary resolutions passed by bondholders for the bond debt, and there are also likely to be other stakeholders who need to be involved, so trade contractors, pension trustees, shareholders, for example. So given that all of these kind of approvals are going to be required, it's obviously important to have in mind some key issues when considering whether a restructuring is viable, and if so, what kind of restructuring that should be. So, are voting thresholds by different creditor and member groups likely to be met? If you need all lender consent for amendment of the loan documentation, how likely it is you're going to achieve that? If you need an extraordinary resolution to be passed to amend the terms and conditions of bond debt, are you really going to achieve that? Is there a risk that blocking thresholds might be used by bond-out creditors or shareholders to renegotiate terms? And if there are likely to be problems with hold-out creditors, that's exactly the scenario where you might be looking to a statutory process with the ability to bind certain minorities into the restructuring proposal. In the UK, until mid-2020, we had two main statutory processes available to assist with restructurings. The first is the company voluntary arrangement, or CVA, and the second is the scheme of arrangement. And since 2020, we also have a new court-based process, the new Restructuring Plan, which was introduced by the Corporate Insolvency and Governance Act, which I'm going to call CIGA from now on, just because it's shorter and a bit easier to say. So let's have a little look at the traditional restructuring tools before we come on to look at the restructuring plan and how that differs a little bit. Well, first, the scheme of arrangement. Although it's a hugely popular process for the restructuring of debts of companies in distress, the scheme of arrangement isn't actually an insolvency process at all. It all comes under the Companies Act 2006, and it enables a company, whether it's solvent or it's insolvent, to make a compromise or arrangements with its creditors or any class of them. And there's nothing in the legislation that actually dictates the subject matter of that compromise or arrangement. So in theory, a scheme could be used to agree pretty well anything that a company and its creditors or members may properly agree amongst themselves. But as I've said, it's a really important part of the debt restructuring toolbox. In a creditor scheme of arrangement, the creditors are separated into classes and they vote on the proposals. And at least 50% in number, constituting 75% in value of each relevant class of creditors, has to vote in favour of the scheme for it to proceed to sanction. And assuming the appropriate majorities of each class are achieved, any holdout minorities within a class of creditor will then be bound. Now, notably, as long as the requisite voting thresholds are actually achieved, claims of secured creditors can actually be compromised or written off under a scheme without their unanimous consent. And that's an important difference between a scheme of an arrangement and a CVA, because CVAs don't bind secured creditors without their agreement. However, because with a scheme all the classes need to vote in favour and there's no ability to cram down a dissenting class, there's the capacity for one holdout class of creditors to cause a scheme to fail. We have seen that happening in the past. A CVA is a compromise or other arrangement between a company and its creditors under the Insolvency Act 1986. So this is strictly an insolvency, an animal of the Insolvency Act. The creditors aren't actually split up into classes, they all vote together, and the voting threshold is 75% by value and a majority by value of unconnected creditors. And there are some important limits to what a CVA can do, because it can't bind secured creditors and it also can't compromise shareholders' rights, which a scheme is capable of doing. But it's a potentially really useful tool if you want to impose a solution on a group of unsecured creditors who would potentially form separate classes in a scheme. And it also tends to be quite a lot cheaper than a scheme because there's usually less court involvement unless there's a challenge, although we've seen there have been quite a few challenges to CVAs over recent times. So, the new restructuring plan. The new restructuring plan was ushered in as part of the Corporate Insolvency and Governance Act 2020 CIGA in July 2020. And it was billed as a kind of a COVID measure, but in actual fact, the restructuring plan element has been kicking around since, I think, 2017-18. It certainly formed part of proposals by the Insolvency Service back then. But of course, it was a great time to actually push it through because it's pretty relevant to what companies will now be facing. There have been a few companies who have already used the restructuring plan to date. I won't read them from the slide, but I'm sure you've probably heard some of them. Now, the new restructuring plan very much has its roots in the scheme of arrangement. The legislators very obviously took a if it ain't broke, don't fix it kind of approach, and they concentrated, it seems to me, primarily on those elements of the scheme which had some perceived shortcomings. And this has led to some commentators calling this restructuring plan a super scheme. And there are a number of similarities between the scheme and the restructuring plan, but it's probably worth just flagging a few of the key ones. Well, first, like the scheme, the restructuring plan is a creature of corporate law, not insolvency law. So all the rules are found in the UK Companies Act 2006. And it's also worth noting that although these procedures actually live in the UK Companies Act, non-English companies often propose schemes and plans. And an overseas company needs to demonstrate a sufficient connection to the UK. Now, in practice, that tends to be a fairly low threshold you have to meet. It can be met, for example, if you've got English law-governed documents that are the subject of the proposed compromise. It can be satisfied with a location of the company's centre of main interest, or the location of its assets or creditors being in England, for example. The procedural aspects of the scheme and a restructuring plan are also very similar. So there tend to be two court hearings. The first one, the convening hearing, examines class composition and procedural elements of the scheme or the plan. And the second court hearing is to sanction the scheme or the plan following voting by creditors and members. And the close similarity means the court's been very happy to actually export some of the case law from the scheme into the plan. So things like class composition has been looked at under the scheme rules and applied to restructuring plans. The approval thresholds are also pretty similar. As I've mentioned already, for a scheme to actually pass, at least 50% in number, constituting 75% in value of each relevant class of creditor or member needs to vote in favour. And that same 75% in value threshold has been carried across into the restructuring plan. But what they dropped is the unpopular majority in number, or what has been called the numerosity test. That doesn't appear in the restructuring plan. And the loss of the majority in number approval requirement is one difference, but there are some other important ones. A first really important difference is while schemes are available to solvent and insolvent companies, the restructuring plan is only available to companies which have encountered or are likely to encounter financial distress. So for a restructuring plan to be available, there are two preconditions which actually have to be met. And the first, as it says on the slide, is the company has encountered or is likely to encounter financial difficulties that are affecting or will or may affect its ability to carry on its business as a going concern. And the second one is that the purpose of the compromise or arrangement is to try and address those problems and, well, to eliminate, prevent or mitigate the effect of those financial difficulties. Now, it's fair to say most restructuring plans that we've seen so far pretty squarely fall within those two conditions, but it was quite interesting quite recently that Amicus Finance, the Amicus Finance restructuring plan was put forward by its administrators, and in that the judgment, the judge said the fact that the company was actually in administration wasn't of itself enough to satisfy those tests. It happened to in that case, but it's obviously not just a tick box, it's something the court does look at. Now, probably the most important difference between a scheme and a restructuring plan is that a restructuring plan provides for cross-class cram down. Now, I can see my colleagues all laughing because I can't actually say that. So it's going to be a really long few minutes for me now. Cross-class cram down, there you go. And that's a feature of the US Chapter 11 Bankruptcy Code, and it's intended to address the problem that's often encountered in schemes of arrangement where you've got one class of dissenting creditors or members who effectively hold out and cause that scheme to fall over. And what the cross-class cram-down mechanism does is it enables dissenting creditors to be bound by that plan if it's sanctioned by the court as fair and equitable, and if the court's satisfied that none of the dissenting class or classes of creditors as a whole is any worse under the plan than they would be in the event of a relative alternative. And that's known as the no worse of test. And the relative alternative means essentially whatever the court would think was most likely to occur to the company if the compromise or arrangement wasn't sanctioned. So that could, for example, be administration or liquidation. It's also necessary for the genuine economic interest test to be satisfied, and that effectively means that 75% of a class of creditors or members who would receive payment or have a genuine economic interest in the company need to vote in favour of it. And that effectively prevents senior secured lenders or bondholders being crammed up by an out-of-money unsecured creditor or an equity class. Now, the court actually retains a broad discretion over whether to sanction the plan. It won't do that, don't do so if the plan or process that's followed by the company isn't considered just and equitable. And the court has also made it clear that there's no presumption in favour of sanctioning a plan even when those cross-class cram-down tests have been met. And so far it's been a feature of 5 restructuring plans, and it was used successfully in Deep Ocean, Virgin Active, Smart Telecom and Amicus Finance. Amicus Finance was particularly interesting because in that case the dissenting class of creditors were actually the most senior class of creditors, and they ended up being crammed up by junior secured creditors who voted in favour of the plan. In Hurricane Energy, which you may have heard of, the judge actually did refuse to sanction the restructuring plan because he thought in that case the conditions for cross-class cram-down hadn't actually been met. And in that case, the restructuring plan provided for bondholders to swap part of their debt for 95% of the equity in the company, leaving the existing shareholders with only 5%. I suppose it's not a massive surprise that the shareholders decided that wasn't a great idea and voted against it. And importantly in Hurricane, there wasn't an imminent threat of insolvency. So the bond debt wasn't actually repayable for about a year, I think. The judge certainly said it wasn't a burning platform. I think that was the term he used. What he said is that what was proposed as the relevant alternative, which was a controlled wind down of the business, which with an ultimate recovery of about 76% of the bondholders and nothing for the shareholders, wasn't actually necessarily the relevant alternative. And the dissenting shareholders were able to put forward some quite compelling arguments, or at least identify a number of possible alternative investment strategies over that year that could have potentially resulted in getting more value. And so it wasn't actually a successful cross-class cram-down in that case. There's also a disenfranchisement provision, and it's fair to say that this provision hasn't actually had a lot of attention in the courts yet. But the court does have the power to exclude creditors or members or a class of them from voting if it's satisfied that none of the members of the class has a genuine economic interest in the company. It probably hasn't been used to date, probably because I think it probably needs to be put forward at a convening stage, which is probably going to mess up a lot of timing and impact on the restructuring timetable. And you need to introduce valuation evidence at that stage. And of course you have the cross-class cram-down, which I've said very successfully then, available. But I'm sure that when the circumstances are right and strategically it makes sense to do so, we might see that being used. Okay. Now, on the next two slides, I'm not going to hover over these because I've covered a lot of this stuff already going through, but it kind of covers some key kind of similarities or differences between the three statutory processes. We'll circulate some the slides after this, so you can look back at this if you want to, or not, please do. Just before moving on to looking ahead, it's probably just worth saying that so far as the corporate trustee is concerned, when dealing with the restructuring plan, you probably aren't looking at wildly different considerations to those that you are with the scheme. But obviously we're in early days, and we'll probably see a lot more of these in the next couple of years. I think it will be a restructuring tool of choice. Okay, so it feels probably as if we're getting back to a bit more normality, but I think life, we all know life is anything but still at the moment. The economic outlook's pretty uncertain, and as John's already covered and Ben's already covered, we are still in quite uncertain times. The ending of the government support measures is going to be an interesting test, I think, because businesses which were obviously most affected by the lockdown, such as hospitality and bricks and mortar retail as well, which was obviously in quite a lot of trouble even before the pandemic, are still going to be big themes, I think. And it seems to be hard, to me at least, to see how we are going to see some businesses that are currently on the edge of viability kind of being pushed over that edge and needing to do some restructuring. I think the insolvency service statistics are really quite interesting. So the number of insolvencies in August 2021 was 70% higher than those in August 2020, which just shows you what a massive effect that the government support measures actually had. So after a period of total stasis during the period of the pandemic, while everyone's propped up effectively by the government, businesses which would otherwise have failed were kept going. And now insolvencies are on the up again. Those figures obviously cover informal insolvency processes and not kind of restructurings that we've been talked about, but they're interesting nonetheless. One thing that has been raised is whether or not we'll see the restructuring plan being used by small and medium-sized enterprises, because the scheme's traditionally been a creature more popular for use by large corporates, largely because of the cost of the court process involved. In actual fact, the Amicus Finance PLC was actually in the SME space, which is an interesting development. So we might start seeing that where it fits the profile, we might start seeing that used in a wider and large corporate space. It also seems pretty inevitable to me that with the increased use of the plan, we'll see an increased number of creditor challenges, most of them centering around that process, that cross-class cram down that we've been talking about. So a lot's going to hinge on assessment of what a creditor's going to get in that relevant alternative, and that's certainly where we've seen some of the kind of arguments so far. Will the restructuring plan mean the end of the scheme? I don't think so. I think it's probably fair to say when you're dealing with a company in distress, the restructuring plan will probably be the more popular choice because it solved some of those problems that we saw with the scheme. But obviously there are distress conditions attached to that restructuring plan, and there aren't for a scheme of arrangement. So there will, I'm sure, still remain a place for the scheme. And finally, whilst they're not topics for today, there are some other measures coming, or some have already come down the track at us, which are going to have an impact on restructurings and security enforcement activity going forward. The first is the National Security and Investment Act 2021, which is gives the government the right to intervene in transactions it considers to pose national security risks. And that actually has a very broad scope, surprisingly broad scope. We're waiting for guidance on that from the government, but legislation is due to come into force early next year, and it already has retrospective effect for transactions that were entered into since the 20th of November last year. And in a similar vein, going forward, where a corporate with a defined benefit pension scheme is involved in a reorganisation, then we've got the new Pension Schemes Act 2021, which introduces a new criminal offence, happily, for anyone engaging in conduct that detrimentally affects in a material way the likelihood of accrued scheme benefits being received. So, and the bar apparently is very low for this new offence, so it's capable of affecting lenders on restructuring financings and potentially new deals. So lots of fun ahead. So thank you very much for listening to me saying cross-class cram down badly. Does anyone have any questions for me and Jayesh? I will obviously get some Jayesh to answer the questions.
You can ask questions on the drinks if you like.
Yeah, or you can ask any drinks as well. I think without further ado, do you have a question? No. In many ways, I'm about drinks. Yes, well, exactly. So without further ado, let's all retire to the drinking bit of the proceedings. Thank you very much.